This video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments in the justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only. Hey, Jamie Carper here. Today we are discussing a Supreme Court story about retaliation, workplace power plays, and the ancient corporate tradition of saying, "We would never punish you for complaining," while absolutely punishing you for complaining. The case is Burlington Northern and Santa Fe Railway Co. v. White, 548 U.S. 532006. Here are the facts. You need no reenactments required. Sheila White worked for Burlington Northern in a rail yard. She held a forklift position, generally considered a better assignment than track labor. She complained that her supervisor sexually harassed her. Burlington disciplined the supervisor, which sounds good until the aftermath. After her complaint, White was reassigned from forklift duty to track labor, more physically demanding and, in her view, a worse job. Then she was accused of insubordination and suspended without pay for more than a month. Later, the company reinstated her and gave her back pay. But during that month, she still had bills, rent, and groceries, because time, unfortunately, does not pause for litigation. White sued under Title VII, claiming Burlington retaliated against her for complaining about discrimination. Here's what happened next. At trial in federal district court, a jury ruled for White on her retaliation claim. Burlington appealed. The Sixth Circuit Court of Appeals affirmed, agreeing that these actions could qualify as retaliation. So the Supreme Court steps in to answer the big legal question. What counts as retaliation under Title VII? Does retaliation cover only ultimate employment decisions like firing or demotion? Or does it also cover employer actions that might discourage a reasonable worker from speaking up, even if job title and pay technically stay the same?
We'll hear argument this morning in Burlington Northern and Santa Fe Railway Company v. White.
Mr. Chief Justice, and may it please the court, Title VII's anti-retaliation provision should be limited to actions that affect the terms, conditions, or status of employment. Otherwise, courts risk becoming referees for every workplace grievance.
But retaliation can be subtle. If an employer can't fire an employee, it may punish them in other ways. Why would Congress protect only against the most extreme actions?
Because a broader rule would be unmanageable. Every unpleasant assignment or schedule change could become a federal case.
So your line is ultimate employment decisions?
Yes, discharge, demotion, serious pay reductions.
What about an unpaid suspension? Even if the employee is later reimbursed, wouldn't that deter a reasonable person from complaining?
It may be unpleasant, Justice Kennedy, but if the employee is made whole.
But during that month, the employee experiences the punishment. That experience may deter others from complaining.
Our concern is drawing a clear administrable line.
Counsel for respondent.
Mr. Chief Justice, and may it please the court, the anti-retaliation provision is designed to prevent employers from discouraging employees from reporting discrimination. The correct standard is whether the employer's action would dissuade a reasonable worker from making or supporting a complaint.
What's the limiting principle? We don't want retaliation law to cover trivial slights.
The action must be materially adverse, not petty or minor. Context matters.
And a month-long unpaid suspension?
That is not trivial. Even if back pay eventually comes, the deterrent effect is real.
So retaliation is about deterrence.
Thank you, counsel.
The anti-retaliation provision serves a different purpose than the anti-discrimination provision. Discrimination addresses workplace terms and conditions. Retaliation addresses fear whether employees will be discouraged from speaking up.
But if we're not careful, everything becomes retaliation.
That's why the standard is material adversity, not trivial harms, only actions that would deter a reasonable worker.
And retaliation often comes in indirect forms: reassignments, suspensions, burdens meant to send a message.
I agree that limiting retaliation to ultimate employment decisions is too narrow, though context matters must still have limits.
An unpaid suspension is a serious economic pressure. Deterrence isn't abstract, it's immediate.
And reassignment depends on context. A move to more arduous work may be materially adverse even without a pay cut.
So broader than firing, but narrower than workplace pettiness.
Justice Breyer has the opinion of the court.
We hold that Title VII's anti-retaliation provision covers employer actions that are materially adverse to a reasonable employee, that is, actions that might have dissuaded a reasonable worker from making or supporting a charge of discrimination. This provision is not limited to actions affecting the terms and conditions of employment. Under this standard, the reassignment of duties and the unpaid suspension in this case may constitute retaliation.
Here's the holding in plain English. An employer violates Title VII if it takes materially adverse action that would discourage a reasonable worker from complaining about discrimination, even if it's not firing or demotion. Not every annoyance counts. Not every bad day becomes a lawsuit. But employers also don't get a loophole where retaliation is fine as long as it's subtle. Why does this case matter? Because retaliation is how discrimination survives. If the cost of speaking up is getting punished in ways that technically don't change your job but very much change your life, then the law becomes something people are afraid to use. Burlington Northern v. White tells us the law looks at reality, not just job titles and HR forms. I'm Jamie Carper. And remember, in retaliation cases, the question isn't, was it official? It's, would it shut people up?